Hello students, welcome to my Indian Corporate Law lecture series. I hope you remember our previous classes on Memorandum of Association, Articles of Association, and of course we need to cover one more document, that is prospectus at incorporation stage of a company. Before starting today's class, observe the things. As a daughter or son, you have your own powers at home, but at the same time, you have some limitations. You cannot play the role of your father or mother at home. For example, assume that your family is in a plan to purchase land. In that situation, you cannot do all the activities of purchasing land all alone. It's your limitation. And as a student, of course, again you have your powers at college and limitations as well. You cannot play the role of teacher or principal of your college. As a citizen, of course, again you have powers, but you have the limitations as well. You cannot play the role of prime ministers or even a Ministry of Port cannot take decisions regarding either military or foreign affairs. He have the powers, but he cannot cross the powers allotted to him or authorized to him. ಸೊ ಆಸ್ ಎ ಸಿಟಿಸನ್ ನೀವು ಕೂಡ ಒಂದು ಪ್ರಜೆಯೇ, ದೇಶದ ಪ್ರಧಾನಮಂತ್ರಿಗಳು ಕೂಡ ಒಬ್ಬ ಪ್ರಜೆಯೇ. ಹಾಗಂತ ಹೇಳಿ ನೀವು ದೇಶದ ಬಗ್ಗೆ ಫಾರಿನ್ ಅಫೇರ್ಸ್ಗಳ ಬಗ್ಗೆ ಯಾವುದೋ ಒಂದು ಡಿಸಿಷನ್ ಅನ್ನು ತಗೊಳ್ಳಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಸೊ ಯು ಶುಡ್ ಬಿ careful regarding the powers allotted to you, and you can act within that powers. And observe these things. So it is the jurisdiction of Punjalakatti police station. So here they can perform the activities, they can perform the duties within the jurisdiction here. So they cannot go to some other places and perform the activities. So maybe it is the place of Sringeri. So he cannot go here and do the activities here. Or they cannot go to somewhere like Delhi and they cannot do the activities. So they should act within the boundaries specified. So everyone and everything is having their own limitations and within which everyone should act. So, by these two observations, we can conclude everything is having their own limitations and within which everyone should act. So, like the same, companies also having their own limitations or their own boundaries within which the company should act. In any case, so they cross the border, they cross their scope. So, in that situation, we are going to call such activities as doctrine of ultraviolet. So, for companies, the scope is defined by the two major documents, that is memorandum as well as the article. So, if the company violates or do the activities which is beyond the memorandum or articles, so we can call such activities as doctrine of ultravirus. The term doctrine of ultravirus, of course, sounds like little scientific or medical term, but actually it's not. So here we can see the word ultra means beyond and virus means powers. So the activities which are beyond the powers of company are called doctrine of ultravirus. So you should be careful regarding the spelling of the term virus. So virus here VIRES and not RUS. It should be very specific, otherwise the meaning will be different here. It means that the doing of the act is beyond the legal power and authority of the company. ಸೊ ಕಂಪನಿಗೆ ಅಲಾಟ್ ಆಗಿರುವಂಥ ಆಕ್ಟಿವಿಟೀಸ್ಗಳು ಅಥಾರಿಟಿ ಏನಿರ್ತದೆ ಇದಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಆಕ್ಟಿವಿಟಿಯನ್ನು ಕಂಪನಿ ಪರ್ಫಾರ್ಮ್ ಮಾಡಿತ್ತು ಅಂತ ಹೇಳಿ ಆದರೆ ಅಂಥ ಆಕ್ಟಿವಿಟೀಸ್ಗಳನ್ನ ನಾವು ಡಾಕ್ಟ್ರಾನ್ ಆಫ್ ಅಲ್ಟ್ರಾವೈರಸ್ ಅಂತ ಹೇಳಿ ಕರಿತೇವೆ. The major intention behind this is to protect the interest of the investors and creditors, because the company is run by the management team. So, in order to restrict the activities of management, so this particular concept arised. So there are three major uh, activities which are allowed to do by the companies. Apart from these three activities, companies are not allowed to perform any activities. So, here the first one essential for the attainment of the objects stated in the Memorandum of Association. So, you know that in a memorandum we have a special clause that is objective clause, which is very important. In the objective class, the companies should specify their all objectives. So, in any case, if the objective is not specified but they are performing the activities means which is ultra vires the memorandum. So, companies are allowed to do the activities only the objectives which are specified in the memorandum. And the second thing, reasonably fair and fairly incidental to the attainment of object. So which is not a major object but which is a supporting to the major object specified in the memorandum. Such activities are allowed. And the third one, otherwise authorized by the Companies Act. So which is not mentioned in the memorandum, the activities which is not supporting to the major objective but which is allowed by the Companies Act. So such activities are allowed. Apart from these three activities, all the other activities are doctrine of ultra vires. So here there are various categories of doctrine of ultra vires. Assume that this the broader boundaries specified by the Companies Act. So the activities performed by the company should be within these broader boundaries. If any activities which is beyond this boundary is considered as acts ultra vires the Companies Act. The activity which violates the Companies Act, so those things considered as acts ultra vires the Companies Act. Consider an example. The company is decided not to pay the proper tax to the government. So, which is violates the Companies Act. Paying proper tax is specified by the Companies Act, but the management of the company decided not to pay the proper tax to the government. So, which violates the Companies Act, which is beyond the Companies Act. So, this particular activity is called Acts Ultra Vires the Companies Act. And the second category of broader line boundaries specified by Memorandum of Association. So, here, if any activity which violates the memorandum, it's called Acts Ultra Vires the Memorandum of Association. Consider an example, increased the authorized capital over the amount specified in Memorandum of Association. You know that the companies has to mention their authorized or the maximum capital to be collected in their memorandum under the capital clause. But if they collected over the authorized capital, so in that situation, it violates the memorandum. So it's ultra vires the memorandum of association. And the third border specified by articles. So any activity which violates the articles, so considered as acts ultra vires the articles of association. Consider an example, directors remuneration fixed at maximum of rupees 10 crore per annum, but actually they paid 11 crore rupees, which violates the articles of association. So it's acts ultra vires the article. And the fourth category is acts ultra vires the directors. So here directors will be allotted with specific powers. So if any activity of directors violates the powers allotted to him, considered as acts ultra vires the directors. Directors are required to pass a special resolution before acquiring a new business, but he failed to get such special resolution. He directly taken his own opinion and he proceeded with acquisition of new business. So which is considered as acts ultra vires the directors. So hope you understood the four basic categories of doctrine of ultra vires. Ultra vires the company's act, ultra vires the memorandum, ultra vires the article, and ultra vires the directors. Let us see one by one regarding the legal status of these ultra vires. So if it is ultra vires the company's act, that is act done contrary to the scope of company's act. So in this situation, it's called void. So here, I hope you remember the term void. So void means not having any meaning or which don't have any legal status. No, don't have any legal implications and which cannot be ratified. So here, ratified means renewing the contract by giving legal status to such activity. So here, all these kind of activities or void which is don't have meaning and we cannot give the legal status even by the unanimous resolutions of all shareholders, even if all the shareholders which wishes to give the legal status to such activity but they cannot give such legal status to them. You can see in the example the decision of not paying the tax to government. So shareholders cannot take such a decision. Acts ultra vires the memorandum. If an act is ultra vires the memorandum, does not create any legal relationship. That means it's absolutely void and even the whole body of shareholders cannot ratify it. Again, even if the shareholders wishes to give legal status, they cannot do such things. Increase the authorized capital to 11 crore rupees. In that situation, which is violated the memorandum and they cannot continue with the 11 crore rupees of capital. Acts ultra vires the articles of association. But here, company can ratify it by altering the articles by a special resolution. So in this case, directors' remuneration fixed at a maximum of 10 crore rupees, but they paid 11 crore rupees. If the shareholders okay with the violation of paying higher remunerations to the directors, so in such situation, they can proceed with the payment of 11 crore rupees by passing a special resolution. So after this special resolution, they can continue with the payment of 11 crore rupees or higher remuneration to directors. Acts ultra vires the directors. The shareholders can ratify by a special resolutions and general meeting. Directors required to post special resolution before acquiring a new business, but they have not did such special resolution. In that situation, which is violated the director's power, but not any specific document, either articles or memorandum. In that situation, they can proceed with the acquisition business or they can give meanings to such acquisition contracts by passing a special resolution in general by passing a resolution in general meeting. I hope you can differentiate between special and general resolution. Special resolution means two-third majority they should get, and general resolution, simple resolution means they should get at least 51 percentage of voting. So you can compare now. Ultra vires, the Companies Act is what, and memorandum is what. So they don't have any meaning and they cannot be ratified. So they cannot renew such contract and they cannot give legal status to them. But in case of articles and directors, so it's a voidable contract. If the shareholders wishes to give the legal status, so they can give, otherwise they can close a contract. And a ratification can be done here with special resolution and here with a resolutions in general meeting. So hope you can identify and differentiate the different categories of ultra vires. Here's a case study of Ashbury Railway Carriage and Iron Company Limited versus Riche. The company was formed with the following objectives. So they have mentioned these objectives in their memorandum: to make, sell, or lend on hire railway carriages and wagons. The major objective is towards the railway carriage and wagons. So they can create, they can sell, or they can lend on hire. And the second one, to carry on the business of mechanical engineers and general contract. So your business of mechanical engineer again related with railway wagons. And to purchase, lease work and sell mines, minerals, land and building. So the third objective is with specific reference to mining activity. So these three are the specific objective. So beyond these three objectives, they cannot do any activities. If they did so, those activities are called doctrine of ultra-vires and which don't have any meaning. But here, these three objectives are specific, but we cannot identify the specific meaning of general contracts. So let us see further what happened in this particular case. Ashbury Railway Carriage and Iron Company Limited, of course, the company entered into a contract with Riche for the financing of the construction of railway line in Belgium. So here, the company entered in a contract with Riche for financing activity. So here we should be careful. So whether this financing activity is included in the objective class. ಅವರ ಆಬ್ಜೆಕ್ಟಿವ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಹೇಳಿರುವಂತ ಮೂರು ಮೇಜರ್ ಆಬ್ಜೆಕ್ಟಿವ್ಸ್ಗಳು ಒಂದು ರೈಲ್ವೆ ವ್ಯಾಗನ್ಸ್ ನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಥವಾ ಸೇಲ್ಸ್ ನ ಬಗ್ಗೆ. ದ ಸೆಕೆಂಡ್ ಆಬ್ಜೆಕ್ಟಿವ್ ಇಸ್ ರೆಕಾರ್ಡಿಂಗ್ engineering works with related to railways, and the third objective was with related to mining. But here the question is whether this financing activity is within the boundaries of company's objectives or not. So here Riche complained that the contract ultra-vires the memorandum. So his complaint is that this financing activity is beyond the scope of company's objective. So it is an ultra-vires the memorandum of association. The question raised was whether that contract was covered within the meaning of general contract. So in the objective, so this term is not clear. ನಾವು ಆಲ್ರೆಡಿ ನೋಡಿದ್ದೇವೆ ಆಬ್ಜೆಕ್ಟಿವ್ಸ್ ಅಲ್ಲಿ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಅಂತ ಹೇಳಿದರೆ ಈ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಫಿನಾನ್ಸಿಂಗ್ ಆಕ್ಟಿವಿಟೀಸ್ ಕೂಡ ಇನ್ಕ್ಲೂಡ್ ಆಗ್ತದಾ ಇಲ್ವಾ ಅನ್ನುವಂಥ ಕ್ವಶನ್ ಅರೈಸ್ ಆಗ್ತದೆ. So if we consider this financing activity within the scope of general contract, then it's not violated the memorandum. So ಈ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಫಿನಾನ್ಸಿಂಗ್ ಆಕ್ಟಿವಿಟೀಸ್ ಅನ್ನು ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಹೇಳಿ ಆದ್ರೆ ಅಂತ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಮೆಮೊರಾಂಡಮ್ನ ಆಬ್ಜೆಕ್ಟಿವ್ಸ್ ಅನ್ನು ವೈಲೇಟ್ ಮಾಡಿದ ಹಾಗೆ ಆಗ್ತದೆ. ಬಿಕಾಸ್ ಇಟ್ಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿಸ್ ಟರ್ಮ್. ಈ ಟರ್ಮಿನ ಸ್ಕೋಪಿನ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ ಕೋರ್ಟ್ನ ವರ್ಡಿಕ್ಟ್. That the court given verdict, contract was ultra vires the company and what? So that not even the subsequent assent of the whole body of shareholders could ratify it. So shareholders ಇನ ವಿಶಸ್ ಇದ್ರೂ ಕೂಡ ಈ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ಮುಂದುವರಿಸಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. The contract is void, which don't have any meaning. The court haven't considered this financing activity within the boundaries of objectives. So the court haven't considered the financing activity within the term of general contracts. ಆ ಫಿನಾನ್ಸಿಂಗ್ ಆಕ್ಟಿವಿಟೀಸ್ಗಳನ್ನ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂತ ಹೇಳಿ ಕನ್ಸಿಡರ್ ಮಾಡೋದಿಲ್ಲ. ದ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ದ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್, ಸೊ ವಿಚ್ ಇಸ್ ರಿಲೇಟೆಡ್ ಟು ಮೆಕ್ಯಾನಿಕಲ್ ಇಂಜಿನಿಯರಿಂಗ್. ಮೆಕ್ಯಾನಿಕಲ್ ಇಂಜಿನಿಯರಿಂಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ಗಳನ್ನ ಹೇಳ್ಬೋದು ಬಿಟ್ರೆ ಈ ಜನರಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ಗಳಲ್ಲಿ ಫಿನಾನ್ಸಿಂಗ್ ಆಕ್ಟಿವಿಟೀಸ್ಗಳನ್ನ ಸೇರಿಸಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ ಗೇವನ್ ದ ವರ್ಡಿಕ್ಟ್. ಸೊ which is beyond the scope of memorandum, so which is ultra vires the memorandum, and for that sense it's a void and which don't have any meaning. So hope you understood the case of Ashbury Railway Carriage and Iron Company Limited versus Riche. Effects or consequences of ultra-virus acts. So, as we said, the first thing is void ab initio. That means void from the inception of such contract. From the starting of the contract is void. The contract will not have any meaning, will not have any legal status. Second one, injunction. So injunction means the court will give the stay order. So any person can break injunction order from the court. For example, so if any activity is going on, in that situation, any person which is not related to the company or not related to the property can bring the injunction order. So here, in that situation, the companies should stop their work wherever they are. ಅವರ ಆಕ್ಟಿವಿಟೀಸ್ಗಳನ್ನ ಸ್ಟಾಪ್ ಮಾಡಬೇಕಾಗ್ತದೆ ಕಂಪನಿಯ ಫೈನಲ್ ಕೋರ್ಟಿನ ಫೈನಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬರುವವರೆಗೆ. So from the issue of injunction order until the date of final decision, they should not do any further activities with related to that particular subject. London Country Council versus Attorney General is an example for this particular uh, issue. The London Country Council in the objective is to run the tramway business, but later they started omni traveling business also. At this situation, a third person brought the injunction order that uh, it is violating the objectives. At that situation, so that they have stopped running omni business, so they can proceed with the business of tramway only. And the third one, personal liability of directors to the company and directors personally liable to the third party. Here, company will not be responsible for such doctrine of ultravirus. Only these directors have to responsible to the company as well as to the third party. So from the personal asset of these directors have to make payment of loss to third party or to the company. So you should remember the four basic consequences or effects of ultravirus. Exceptions to the doctrine of ultravirus. So here we made a list, and under these conditions we cannot apply the rule of doctrine of ultravirus. The first one, property acquired by the company by ultravirus expenditure. By paying higher amount, the company has acquired some property. In that situation, they cannot apply the conditions of ultravirus. Property acquired by company under an ultravirus, the contract, which is beyond the power of company. They made a contract and acquired property. Again, in such situation, it's an exception. Company takes an ultra-virus loan and uses to pay off its own debts. ಆಲ್ರೆಡಿ ಒಂದು ಲೋನ್ ಅನ್ನ ಇರುವಂತ ಲೋನ್ ಅನ್ನ ರೀಪೇಮೆಂಟ್ ಮಾಡಲಿಕ್ಕೆ ಹೊಸ ಲೋನ್ ಅನ್ನ ತಗೊಂಡ್ರೆ, in that situation it's an exception. If a person borrows money from the company under the ultra-virus contract, so ಕಂಪನಿಗೆ ಲೋನ್ ಅನ್ನ ಕೊಡ್ಲಿಕ್ಕೆ ಪರ್ಮಿಷನ್ಸ್ ಇಲ್ಲ, even then it lend the amount to third party. In that situation also we cannot apply the rules of ultravirus. Payments by directors ultravirus the company. Directors ಆ ರೂಲ್ಸ್ ನ ಬ್ರೇಕ್ ಮಾಡಿ ಪೇಮೆಂಟ್ಸ್ ಅನ್ನ ಮಾಡಿದ್ದಾರೆ. So you can ask why we cannot apply the rule of ultravirus in this situation. So here in these situations, if we apply the rules of ultravirus, it adversely affect the company. So for that reason, to protect the company's interest, we cannot apply the rule of exception. We cannot apply the rule of doctrine of ultravirus here. And the last exception is that liability of the company for ultravirus, the torts of the employee. Here, the company will be responsible for the activities of employees only under two cases. In the first situation, the tort was committed in the course of an activity which falls within the scope of company's memorandum. If the employee's activities is within the scope of memorandum, then company will be liable. Otherwise, employees should be liable. The employees committed the tort within the course of his employment. If the role of employee is specified by the company regarding such ultra-virus activity, in that situation, company will be responsible and not in any other case. So, hope you remember all the things regarding doctrine of ultra-virus. So let us have a small quiz so that you can record all the concepts and you can evaluate yourself how much you got from this video. Ultra-virus means, I hope you can able to recall the things. Ultra means beyond, virus means power, so which is beyond the powers. And void means, of course, you can easily answer this. Void means the contract or which don't have any legal effects. Consequences of ultravirus or, of course, hope you can able to recall the four consequences. That is, the contract will become void ab initio, and any person can brought the injunction order from the court, and directors will be responsible to the third party as well as to the company. Any one exceptions to ultravirus? So here we have seen 6 major exceptions to ultravirus. So it might be like property acquisition from ultravirus expenditure, property acquisition by ultravirus contracts, or loan taking or loan giving, or director's expenditure, or the company's liabilities for employees. And the last question, Ashbury Railway Carriage and Iron Company Limited versus Riche is an example for, of course, ultravirus, but ultravirus belongs to which category? We have seen 4 category. There is company such, acts ultravirus the memorandum, acts to ultravirus the article, and acts ultravirus the director. Hope I can able to answer this question. It's acts ultravirus the memorandum of association. Thank you for watching. Take care and happy learning. Can meet in the next class.